presidency, and an all-inclusive cabinet? It's a question. But did he get wrong counsel in directing all former ministers to stay on as what? Caretakers? We'll do the analysis here on your most authoritative news analysis show, Newsfile. We're coming to you live from the Multi-TV studios. This is Joy News Channel. You're listening to us on radio, My Joy, on Joy 99.7 FM and over a dozen of affiliate stations across the country. And you're also listening and watching via myjoyonline.com and Multi-TV World/streams. Your views are big on this show, so I welcome them. Questions and comments, let them come in. 1422-1760. Post your comments also on our Facebook wall. Just go and search for Joy 997 FM. You can also send me an email at newsfile@myjoyonline.com. My guest already seated in the studio, Professor Mike Oquaye. He's a former second Deputy Speaker of Parliament. He's a lawyer. I'm sure you know about that. A very good morning to you.
Good morning.
Welcome to the show.
Good morning, my friend.
Nana Ato Dadzie is a member of the NDC legal team, a former Chief of Staff in the Rawlings administration. Good morning and welcome to the show, Nana.
Yeah, good morning.
Ernest Kofi Abochi, he was my lecturer. He is a senior lecturer at the Gimpa Law School. Good morning and welcome to the show, sir.
Thank you so much.
And Abdul Malik Kwaku Bako Jr., a regular guest on this show, will also take his seats with his documents already being sent in. And Anato Dadzie is pointing to a part of the document. I tell you, this is not all of it. There's a bag that will come in very soon. Now, my distinguished guest, I welcome you to the show. And this is how we start right away. I'd like to start first with Professor Mike Oquaye. We are waking up to the news that the New Patriotic Party, and I must put it in the right context, Nana Addo Dankwa Akufo-Addo, 2012 flag bearer of the New Patriotic Party, Dr. Mahmoud Bawumia, a 2012 vice presidential candidate of the New Patriotic Party, Jake Otanka Obechebe Lamte, 2012, or is a chairman of the New Patriotic Party. They are the petitioners in what I have described as the biggest legal battle in the political history of this country. They are the petitioners in the case currently before the Supreme Court. We are learning this morning that they are no longer interested in challenging the composition of the courts. And I have in my hand a letter supposedly coming from the Akufo-Addo, Prempeh and Co. chambers. And it was written on the 11th of January 2013 to the Registrar of the Supreme Court, Accra. And it says, Dear Sir, writ number J1/6/2013, Nana Akufo-Addo and two others versus John Dramani Mahama and another. We act for the petitioners at its sitting on the 10th of January 2013 to consider an application for joinder brought by the National Democratic Congress, NDC, in the above instituted suit. An objection to the composition of the court was taken by counsel for the petitioners. The court has directed that the objection be made by formal application. We have, upon consideration, decided not to pursue the matter in order to facilitate an expeditious determination of the petition. This will, in addition, ensure an early hearing of the application for joinder. We would therefore be obliged if the application for joinder could be fixed for an early hearing. Yours faithfully, signed, Akufo-Addo, Prempe and Co., lawyers for the petitioners, and copy to Samuel Kujo, Law Trust Company, Trust Towers, Asylum Down Accra, Tony Lita, Lita Brew and Co., Kanda Accra, and Lanes, Kwashi Idon and Co., Adabraka, Accra. What happened?
Oh, thank you very much for the opportunity to discuss some of these very important matters with your cherished viewers and with our countrymen and women. It's our duty to do so. This is the first time I'm hearing of this letter, which you say you just got. So let's go back a bit before we come to that. In terms of people making very important contributions as to why this objection was raised, a number of comments have been made which need to be put.
I must first of all say sorry. Abdul Malik Wekubako Jr. has joined us in the studio. Good morning and welcome to the show, Abdul.
Yeah, thank you.
Thank you very much. Prof, continue.
Yes, which need to be put in the right perspective. In the first place, is there something wrong when a person challenges a member of a panel or a judge presiding over a case? How is it done? At what stage of the proceedings? Let me say that it's a legal practice that the first opportunity rule must be applied. In other words, the moment you have an opportunity to challenge a judge on a panel or a sole judge trying a case, you must do so at the earliest possible opportunity. Among other things, even the Constitution itself says in Article 157, subsection 3, it says, without prejudice to clause 2 of this article, no person sitting in the Superior Court for the determination of any cause or matter shall, having heard the argument of the parties to that cause or matter, and before judgment is delivered, withdraw as a member of the court or tribunal, or as a member of panel determining that cause or matter, nor shall that person become functus officio in respect of that cause or matter until judgment is delivered. In other words, this also means that if you have an objection, then you must raise it before hearing starts. It must be very clear to the public that until the parties went to court first time, no one knew who the judges would be. So if anybody raises an objection at that particular period, it must not be said that this was being done in bad faith, in malafide, because that was the first opportunity. Is it something that happens? Yes. And it's very, very important. Look, even though you have read this letter, I want us to understand some circumstances in which a judge may recluse himself. Someone may say, and in fact, why it must also be done not in the first instance publicly, but privately. And that is the practice in court. If you object to a judge, you don't just get up and start saying things. You give an opportunity to be heard in private. Both counsel are there, so in a way it's not private, but actually it's between lawyers and judge. What happens, therefore, is that you then give the judge an opportunity to want to recluse himself by way of what you have said, or have a formal hearing in public. And let me tell you, some of these things can be very personal. Someone may say, your father and my father had a fight when one person seduced another person's wife, and it led to a separation of our families. We come from the same town or village, but since then our families have been fighting and don't speak to each other. Therefore, you cannot be judged over me. This doesn't have to be said in public in the first instance. A judge may understand, and the judge may recluse himself. that is the end of the matter, because there are others at any given time. A judge may say, let this matter be formally heard in court. Lawyers are also very, very cautious in these matters, because you see, your facts are not necessarily always correct. So, as for going public in the first instance, you don't do it. Therefore, I want people to understand that the NPP, the lawyers who made this objection and asked for a private, or what we call, we don't talk about it, the thing being private.
In chambers.
When something is in chambers, it's not really private. And like some of the things that, comments that were made, after the Yanko and so on, it was not as if to now veil this thing in allegories and in secrecy. No, it is part of the process. And in fact, the right thing was done.
You say it's not in private because lawyers of the other side
both
will be
sides
part of it.
are part of it.
All right.
Except that we lawyers and judges want to give a certain dignity to the first instance, having gone by the first opportunity rule. Now you want to first of all go in the first instance by way of an application in chambers, and the judge, like the instance I've given you, and there can be so many other instances. We have been fighting over this person, is this person, and so many things. When that happens, there will be the judge excusing himself, but it does not therefore mean that people wanted it to be in private or in secrecy.
Sorry if I'm a bit ahead of myself on this one, but I must ask this question, which I feel follows naturally, that if the legal team of Nanado and Co. felt genuinely that opposing that the presence of that particular judge on the panel was crucial to the determination of the case, and you are saying that what was done was not in bad faith, if they believed so, and that it was important to get that judge out of the panel, why the change?
No, you realize that the impression has been given that certain things are being done so as to cause delay. These are the very people who brought the case. It was being said on radio, and they were saying that things must be done quickly. They don't believe in the case. They don't intend that the case must move with expedition, and therefore they are taking steps to frustrate the process and so on. They may well go and think back and say, look, let us forget about all these things. Let us move on with the case so that the case is heard by the judges. But I'm saying that it is very, very clear to my mind, and I'm explaining this is very, very important for the public to note, that these applications are very common. They are not done in public, and those who were there, you realize that the judge, the presiding judge, Mr. Justice Atumuba, made reference to the pronouncement or the submission of Mr. Kwashi Aiden, and he referred to the fact that as he sat there, he could see he was the most senior member of the bar at that time. His view was that, let's go first into chambers, and then we will know. After that, we could discuss anything else in public. I want this matter to be very, very clear, because it was not meant to delay anything, and it was also done in absolute good faith in the circumstances.
In absolute good faith,
yes,
and seeking fairness in the determination of the matter.
Exactly.
But the question now is that with the presence of that judge that you were opposing, still now allowing the process.
In fact, you realize that the NPP lawyers, lawyers for the petitioners,
Nanado and Co, the petitioners.
Lawyers for the petitioners, did not speak about what the nature of the objection was. It was only about matters, yes, in public. It was only a reference to composition. If anybody spoke about that part in public, it was the other side who made mention of that in public.
Okay.
You see, there's a certain amount of judicial and legal profession discretion in these matters.
I return
and
to
the practice of the profession.
I return to you. Let me hear from Nana Atudaze. When you hear and when you read the letter, you feel relieved now, because you had said that this is part of a strategy to delay the process unnecessarily. So now You're happy that it won't be long. You are likely to have your joint ahead.
Absolutely. Thank you very much. Thank you for the kind listeners. I mean, I really, we saw this document last night, at our legal meeting. We were not surprised, because really, I mean, I think that maybe just a little advice to the other side, that they must hasten slowly. We think that the whole application, the entire petition, was brought in haste. On the face of it, you can see gross errors, just ordinary arithmetical errors, avoidable errors. They are on the face of the pleadings.
Then that should be good for you.
Well, but it's a bit of a waste of time for us too. We have the grave business of administering the state, having been given the mandate, you understand. But we must respect every case. I keep saying, as a lawyer, there's no small case for me. And that goes from our legal team whole. Now, we are saying that I think a good advice to the NPP and their legal team is that they must hasten slowly. We are getting into plenty of problems. From one, as I said, their pleadings. Two, their approach. You come to Supreme Court, the highest court of the land, and the first thing you do, you get up oral application to challenge the panel. You don't do such a thing in the Supreme Court. The Supreme Court is a court of record, the highest court. If you want to raise any application, it must be by way of a motion. Of course, you must have thought through your objection before coming to court. It isn't like you got there and, hey, presto, you have. Now, so you see the panel and then you're uncomfortable with it. Yes, okay. You can indicate that we are a little uncomfortable, we may want to do something. You get me? And then you come in proper style.
I don't get you clearly. You say you don't do that, and then
yes,
in another breath you say you can raise an objection.
No, what I'm saying, in proper form. When I say in proper form, you must come by way of a formal application. You understand? You can indicate to the court that you want a little break, you want to come back in proper form. That's what we term. Now, for me, I ask myself, so what must have changed? You understand? They saw the panel and they had a problem with the panel. Last night, they go into a caucus and then come back and say, oh, we've withdrawn our application. Didn't they think through it before raising the objection? You understand? Now, significantly, what they've done, it's on my iPad, is that they've written a letter, a bare letter, to the registrar of the court, saying that they are no more interested in pursuing the objection against the panel. And the application should be considered as having been dropped. The registrar should fix a date for the hearing of the motion for joinder. Prof knows that cannot also even be the procedure.
Why?
Why? Because you don't go to the Supreme Court, make an application, the court makes a formal record and says that come back by way of affidavit stating your grounds for
Why
objection.
do you communicate to the court?
Yes, I'm saying that.
How do you communicate to the court?
I'm saying that you will have to ask the registrar to, by way of a letter, to have the court sit, and then you bring up a formal application withdrawing your
oral
objection. No, yes, that oral application, which has ended up into a written order of the court. You see, there's a pending written order of the court that you should do something. You don't just write a letter to registrar, tell the court that we are no more interested in it. What happens to that written order? There must be record that written order itself has been revoked. Another point we want to make is that, honestly, I mean, I think that, Prof, you have to come along this path. When you go and stand before the highest court of the land, and you accuse a panel, assuming you say you didn't mention any particular person, you accuse a panel of likelihood of bias, you understand, that you have a problem with it, and you don't identify the person, you put all 9 judges in a problematic position.
But you have already told the world what was
no,
said in camera.
I'll tell you. You get me? you put the entire panel into disrepute. Then, what do? The right thing. If you change your mind, the proper thing to do is to go before the people, the 9 judges, and say, Lord, there was a misapprehension. We are sorry. On bended knees, we apologize for whatever. And then you back out. That's a more honorable thing to do. You don't just write a letter to a registrar. Tell them we are no more pursuing it. What about their reputation? You understand? Then that rolls to the apex point that Prof is rightly saying that their own legal team in court did not openly indicate who the judge was.
That is so.
No,
Yeah.
I'm saying when they met in chambers, they did discuss this frankly with the members of the panel.
Yes.
But when they came out,
Yes.
they did not come and throw it out to the public in that way.
Yes,
That
our
came
legal
to be a
team,
propaganda.
our legal
That's
team in court,
Important.
our legal team in court, be careful, our legal team in court has not also mentioned anything. Lawyers, I'm saying, I know what I'm talking about. Now, we've indicated already that their fresh MP.
No, I mean, just a while ago, we played a footage of you. We played a video of you.
Yes.
And you specifically mentioned that what you understand is that the judge that they have an objection to on the panel is Justice William Atuguba.
That's what I'm coming to.
They
In the
brought it
moment,
to the
no,
public.
that I
You
said
brought it into the public.
I said it. I'm not a member of the legal team in court. I'm a member of the NDC legal team. I'm not a member
of the president's legal team.
No. I'm saying that I am not a member of the team announced in court making a presentation. Let's draw the line. You understand? In the same way, Titus Glover is not a member of their legal team. I don't know whether he is a lawyer, but he was
Titus Glover is an MPP
It's
MP.
an MPP MP. He was spouting out publicly, even before the panel sat, that it was Mr. Justice Atuguba, and the relationship because was their cousins or something, appointed by the president. After we've gone out, you played it this morning. There was Sir Charles, General Secretary of the MPP. He was saying more horrendous things, really more horrendous, that they are even going to come out with a more challenging thing against that judge if he decides to sit. You heard him. He mentioned Mr. Atuguba. Because you did say that. No, just a minute. You were, Prof, just me land.
Prof, kindly.
All due regard.
Just let me land.
Do me this, Prof.
Comments about horrendous and this.
Respectfully, Prof, do me this.
I'm sorry for
just make a note.
For the words
just make a note, and I'll return to you.
In your ears. But the reality is that when you go and stand before cameras and say that a judge has misconducted himself in the past, and that you have more material and information, and that if he's pushing you to produce the material, it will be even worse. There can't be anything more than horrendous. Now, if you turn up the next day or two and say, "Oh, we are withdrawing the work," he's General Secretary of the MPP. He's not an ordinary person. I'm saying that the last of it is, or the point I'm making is that all the 9 judges, particularly Justice Atuguba, and the people of this country are entitled to an unqualified apology from the legal team that went, one, to make some allegations of impropriety against the judges, and also to frustrate and delay this trial.
An unqualified apology for doing what is allowed by the law. Just hold it on there. Now move on to you, Ernest Kofi Abochi. I want to look at you standing, sitting as it were, someone without interest whatsoever in the unfolding, case, and then hearing Professor Michael Kwe and hearing Nana Atodazi. Strictly in respect of the procedure in court, is there anything being done wrong?
Being done wrong in terms of the application or in terms
of the objection that is raised and in subsequent, withdrawal through a letter to the court through the registrar.
Right. Motions are normally to be made formally, but by practice, it turns out also that motions are sometimes made on the spur of the moment orally, in which case the court has a discretion to advise the party to come formally. That is not to say that when a motion is made orally, the court may still not go ahead and rule on the motion. So it turns out that the court often rules on motions that are made informally and therefore orally. And so parties sometimes weigh their options when they think they don't have time on their sides by making oral applications. And if the court thinks that the gravity of the application is of such a nature that he would want things on paper, he would advise the parties to come formally. The advantage of formal motions is that they also enable the parties to verify their statements by application, by affidavit evidence. In which case, the parties would actually, depose to specific facts in respect of which they actually come by the motion. That enables the court to properly then assess, if you like, the balance of facts and evidence and statements that are being made, and to make a determination appropriately. And so it is not out of practice that a party may come informally, as I think the MPP did. As Nana said, and I think that's my understanding of his position, he felt that the gravity of this case was of such a nature that it would have justified coming formally, i.e. coming by a written motion. I think the problem, however, is I'm not quite sure, and again, I think I'm a little bit confused. I'm not quite sure if the application or the objection was made against the Supreme Court en masse. If it was made against the Supreme Court en masse, in which case the applicant was saying that we are not comfortable with some of the justices on the Supreme Court, then I can understand what Nana is saying. If the application, however, was made specifically against the sitting justice, then the assumption was that by the time they went to court, they had not seen nor known which judge was going to sit on that particular panel. That would be the assumption. And if that assumption is correct, then it means that they could possibly not have come by way of a written motion directed against a specific judge with particular facts in respect of which they raised those objections. And so that understanding should be made. So again, I'm not quite sure what the nature of the application was. Listening to Nana, my impression is that it's against the Supreme Court en masse, that they were not comfortable against all the justices. That would be understandable then, that they would have come earlier with a formal motion. But if it's against the specific judge,
from what we
then
understand,
being the first hearing,
from what we understand, they went into chambers. And when they went into chambers, they disclosed the nature of it and were asked now to put it formally.
Right. But again, was it against that judge? If it was against that judge, then I guess my position is that the assumption is they wouldn't have known, being the first hearing. This was the first hearing in court. Normally, if you're going to court for the first time, unless you know, for the high courts, you can tell the high court one is manned by so-and-so judge. But for the Supreme Court, a particular judge will be designated by the Chief Justice. And ordinarily, you wouldn't know on the first day. So the assumption is that you wouldn't know. But if they didn't know, then the assumption is that
2 hours before, an MPP MP was on radio mentioning the specific judge and saying they are going to take an objection against him.
Right.
This particular member of parliament, Mr. Abuchi,
right,
actually mentioned the night before.
Yeah.
But how important is that to the MPP legal team, the legal team of the petitioners?
Well, it's interesting, and for me, you can read all kinds of things into it. One possible reading you can have into this is that somebody somewhere knows something which probably the rest of the world didn't know. That could be informal. But again, we can all make assumptions. But at this point in time...
What I'm asking is, should it be held against the legal team of the petitioners that a member of their party,
right,
the night before, has spoken about who was going to preside?
How would he know?
And this is the particular person.
Right, how would he know? I guess, the point I'm making... Correct. I mean,
that's why the people of this country are entitled to know. We must investigate this.
Question is that he is a member of
we must
parliament.
investigate it.
He is not part of the legal team. Should it be taken against the legal team?
That's the point I'm making. Let's face it. And, Nana and Prof, my distinguished seniors at the bar, I think they clearly understand how some of these things work. The position is this: what happens outside of court is not before the court. And so, we know we can say all kinds of things. As far as the court is concerned, it is not cognizable. So what Nana is saying, again, let's understand that this is a political matter. Regardless of how we try to professionalize it and speak legally and all that, the political realities are there. We can't close our eyes to that. And therefore, the discussion between Nana and Prof, we can see a lot of things happening, which is really sometimes strays out of the legal. But you're asking me to, if you like, tamper the toe being go strictly professional. I would say the things that happen outside the courtroom are not before the court. If you are going to appear before a judge for the first time, not before a specific court, you cannot know who the judge is. Therefore, if you say all kinds of things, it could be assumptions, it could be speaking from facts, it could be having spoken to somebody, but these are all assumptions. As far as the court is concerned, they wouldn't know whom they are appearing before. And that's what I'm saying, that if the objection is specifically directed at the sitting judge, then we can fairly assume...
That's what it appears to be.
Well, exactly. Then we can fairly assume that they ought not to have known whom he was at the time they were appearing before him. And
Should we be interested in knowing how they got to know?
You are saying they. Nana, you repeatedly say they.
The person. You see, I mentioned two persons.
No, can I make this point?
Yes, please, go ahead.
You are saying they in reference to the party as New Patriotic Party.
Yes.
You are not saying they in reference to the legal team.
Absolutely. I'm saying they, one in relation to the MP who was saying this 2 hours before and the night before. I'm saying this about the General Secretary who immediately after said, if he's challenging us, we are going to unroll more.
Don't take us back. Now, let me bring you in
This
briefly.
country is entitled to justice.
Let me bring
We are
Professor
entitled to
Quaye
fairness.
briefly for a reaction. And I would want to come to Kweku to tell me what questions, what is going through his mind as he follows the entire process. Now, quick reaction to what you wanted to say about Nana Todazi.
I want that you let us go on this matter one by one. It will help us all. And basically because we are here for public education.
That is so.
Those of us here, we know the basic things. But you see, things must not be veiled in allegory. No, should our people be confused? And that is why there's a need for discussing these matters. You see, matters that have been said elsewhere, including those pronouncements by my good friend, whom I worked with on the transition team, who is at one time not an advocate in court, but also a member of the legal team, and who made legal pronouncements after the event. I mean,
that's an interesting one.
These are very interesting matters because he was trying to draw a very thin line, But I've made it very, very clear, and I'm glad our good friend, the lecturer, is making this distinction very clear. And among other, the first opportunity rule that we use generally in court, if you have objection, the first opportunity rule is that the moment you have the opportunity, say it. I say it is reinforced by Article 1573 of the Constitution, which I've read out also very clearly. And if you now bring in matters of errors of the face of the record and that we must hasten slowly, well, we will come to that aspect, I believe, as to the nature of the case that is in court and matters regarding some of the details. The only thing we can pronounce upon is what the verdict should be, which will be contempt of court. But we are entitled to express general views, basically to enlighten the public. You see, you cannot say that after the oral statement, when you are asked now to go and put this into writing, you have done your bit, like I was saying, by way of what is the first line of action. All those comments, therefore, about the fact that it was done in bad faith, and it was a way of trying to do things in secrecy, going to put the trial in Kukwem, whilst in actual fact, you people are saying that now there should be TV. All this I'm saying must be explained so the public will know those statements were wrong.
Okay.
And for that matter, we don't need also an application by way of a formal application necessarily. The court says you want to do something. The court did not fix a date. Sine die. It said, sine means without, die means in Latin day. There's no day. That too was interpreted to mean that, they have caused the whole thing to be put in a limbo. We did not cause it to be put in a limbo. It was to bring things back to the
But can I ask you this question briefly? That as a very competent legal team, is it fair to suggest that going to the Supreme Court it is very reasonable to have presumed that being the most senior judge, he would have been the one to chair
The second most senior.
proceedings. The second most senior. He would have been the one to chair,
No, you
proceedings.
wouldn't-
And I am told that also that by Nana Kumia that what Titus Glover said was conditional. He said if Justice Atuguba was going to be part of the panel, then they would raise an objection.
And there's a big case, Tubeville against Savage. Very, very important. That means if anything is preceded, prefixed by a condition, it has a different kind of interpretation whatsoever. Because you can say, if it is chaired by the Chief Justice, it's reasonable. The Chief Justice could have chaired it. If it's chaired by the Deputy Chief Justice, and then that too will have the consequences. In fact, the Constitution says that the Chief Justice shall chair or the next most senior judge of the Supreme Court. So actually, everybody should know and could know that in this case, if the Chief Justice does not chair, the next most senior, who is Justice Atuguba, should chair.
Okay.
So these things,
Sorry, but
they are well known.
We'll take our time and get into more detail. This is Newsfile. Is brought to you in association with MTN Everywhere You Go and Bank of Africa. Now, my question to Abdul Malik Okubaku Jr. to you is that you sit and you observe what is going through your mind.
Well, I've listened to 3 top lawyers, and as a layman, I will make my input. I'll start with the Titus Glover one, which I think it's a red herring. He was speculating. It was premature. As a member of parliament, I think he should have been a little bit more cautious. I think it was indiscreet. And I'll be honest with you, I've told him this myself. That's why I feel comfortable saying it. But it provided a cover for those who wanted to play mischief with what he had done to do so. And my good friend, Mr. Nana Tudazi, I think, took full advantage of that and publicly used it, to make a point. I thought what Nana did and what subsequently some other NDC personalities, lawyers and things did was also unfair to the process, because in the open court, no name was mentioned. In camera, I'm told the person was identified. So whoever came out of the in-camera session and did a disclosure using Titus Glover's thing to make a point, I think was also unfair to the process. In any case, as for the call for investigation, I think it will be an exercise in futility. How are you going to be able to pin Titus Glover down to say this or that person gave me this information? I was speculating based on a certain point you just made in terms of ranking. He was thinking that possibly Justice Atuguba could be part of it. That may be true or may not be true. For all you know, he got information from within. I don't know. But I'm saying that it's an exercise in futility to subject that thing to an investigative process. You will get nowhere. It will be a cul-de-sac. So we ought not to even think about it unless it's for purely political propaganda purposes. Now come to the other part, and I've been listening, I've been doing my little research. The question of when and how to raise an objection. I'm not sure if I heard Nana well, that if it is the Supreme Court, then the standard is higher. In principle, I have seen at the Court of Appeal, the Dan Abu Dhabi case, Tony Lita, who incidentally happens to be part of this process, if you recall, raised an objection to the participation of Justice Herita Aban on the panel. He did so in an open court. I don't recall that he came with a formal motion. Obviously, because he might not have known who and who were going to constitute the panel. So he came, saw the panel, and raised an objection to the specific person. Yes, I'm coming. So, but the point I'm making here was that there was no formal motion. That's the distinction I'm drawing. He couldn't have come with it, I believe so, because perhaps he didn't know who and who were coming on. So he did make that objection orally. That's the emphasis. Mr. Chachuchikata, again, incidentally, part of this same process, if you recall, he had filed a certain motion talking about a bias of Justice Henrietta Aban. On the panel was seated Justice Broby. Judicial Qatar raised an objection to the participation of Justice Broby in an open court, to the effect that Justice Broby apparently had sat on an administrative inquiry, committee of inquiry, relative to the petition, a complaint that Tony Lita had made against the lady. Nothing to do with criminal or any conduct on the part of Justice Aban. Justice Qatar felt that once Justice Broby had sat on that committee of inquiry, and apparently the committee of inquiry had given Justice Aban a clean bill of health, because he was talking about the bias, possible bias of, or the alleged bias of Justice Henrietta Aban, Justice Broby could not sit on the case. He raised this in an open court. Justice Broby immediately excluded himself. You call it recuse.
Yeah,
am I right?
Himself. And that may sound like a fair,
I am for that principle. Yeah. I am for that attitude. But I'm told that too, if you make an absolute out of that, you could create problems for the judiciary. There is this thing they call shopping for judges. And if you are not careful, if you become that comfortable, very relaxed with that principle of, okay, I've excluded myself, it may create precedents for others to always go shopping for the kind of judges they want. It's a tightrope that this matter raises.
But there are times when the judges themselves, a judge himself, knowing of his involvement to a certain extent about certain matters that are before him, would openly say he would want to recuse himself. And I have encountered that situation before at the Court of Appeal.
I am for that.
Yes.
But I cannot substitute what I am for what others are for. And there's a general problem out there. The judiciary's own integrity has to be maintained. Okay? Because if otherwise, we may have a situation where anytime you don't want a particular judge, you go out and shop for another one. It's a very tricky situation. I'm sure the lawyers here can explain it far better. But there's a more horrendous one, and I'm choosing in a nice view. Today he's giving me a lot of ammunition to proceed. You recall this case, what's the case? The Republic versus Idrusu Idi, alias Madugu and 14 others, the Yana case. And you recall that
Which law school did you attend?
The streets, on the streets.
That is most recent.
Rexford Redu, I think a state attorney, raised an objection to Justice Opon's presiding over the thing. He began by saying that it was a preliminary objection. He says, my lord, this is a preliminary one. We intend even filing a formal motion to that effect. So in open court, he made an oral objection and then indicated that they would subsequently bring a formal motion. But the horrendous aspect is what happened subsequently. If you recall, a Deputy Attorney General, a Minister of Justice, publicly made serious allegations against this particular judge about him going to beer bars, drinking with people. What is not fair?
No good.
You are just making a point.
Really
what is not fair? No, please, what is not fair?
You're
not getting the point.
Let's stick to the issue.
I think he's referring to facts to support the process.
I am
sticking to the
No. Then you're not getting my drift. I am sticking to the issue where people, after raising objections, subsequently maligned others with unsubstantiated allegations. You have just said so here about what other people were saying about somebody.
John, not the other people.
You just said so. General. And I'm talking of a Deputy Attorney General. So why am I wrong? Okay, I mean, you are at liberty to cite a General Secretary of a party, and I agree with you. He's of high standing and ought not to speak in a certain language, a certain way, relative to such matters, especially bordering on the integrity of justices. I agree. The principle is right. And I took a cue from you. And I am suggesting that there was nothing more horrendous than what a Deputy Attorney General did in the same vein. And you recall that subsequently, when the judge gave the opportunity for them to go and bring the formal motion, when they came back, they didn't come with the motion that he had asked for. They came with another type of motion. And the judge just went into his chambers, came out and recused himself, but referred to the things that the Deputy Attorney General had done and said that his integrity and that of the bench had been undermined. So that is the relevance of the point I am making.
But if I may,
I have not introduced any irrelevant issue in this discussion, and I want you to guide us on this matter I have made. It's as as relevant as the point Nana Atudazi made. Square up. So I don't want people to get an impression that I have said something that ought not to have been said.
Conclude in 2 minutes. I'm bringing in Nana Atudazi. Conclude in 2 minutes.
Well, I'll tell you something. There are many reasons. I've gone through some of the research. I'm told, if you recall, there was this objection that was not successful. The Salah case. There was the point about Justice Aparu and Justice Sowa, if I'm right.
It doesn't involve BS. Drinking beers, it doesn't involve that.
Yes, but the one, Justice Aparu, was that he was an intimate friend of Salah.
Correct. And they were seen drinking before.
That's right. And the other one was that it was a brother-in-law to one of the victims of Apollo 568, and indeed had even gone to plead with a member of government for the reinstatement of the person. So there are sometimes bases for raising, but that was even unsuccessful.
Yes, correct.
Okay? There have been many other cases of people who have cited possible bias. The Akufo-Addo Kwasi case. Chachu's own case versus Chief Justice and Attorney General. Right. He went for a second motion that the Chief Justice, had been part of the first panel and being the one who had empaneled the theme, should not sit on the subsequent one. Am I right?
Correct.
Some of them were successful, some were not successful. The point I'm making is that as far as a layman like me, I know the practice of raising objection, whether orally or formally or both, are not unusual. These are practices allowed by court. And to be honest, I think that I go with the Justice Brobe angle, even though I know it is not an absolute. And if it becomes an absolute, it is dangerous. I appreciate that point. But what has happened today, I wasn't in court. My reporters were in court. If I'm wrong, I'm subject to correction. The reaction of Justice Atuguba, I'm told even before the in-camera thing, and which you quoted, I think you were
Yes,
quoting
I did.
it.
Yes, I did.
The body language, the import of the statement, and of course, within the context of what the NPP did, even though they have withdrawn, I think in a way has set him up. In my candid opinion, he may or may not go on, but it makes his role in this process very challenging and difficult.
Is it not about how you interpret what Justice Atuguba had to say? We'll get to
And
that.
the body language. That
Yes.
came with it.
Absolutely, absolutely.
But this is a question I think that ought to be answered. Do you feel that the NPP is now running away from the standard that they ought to prove to have the objection sustained? Real likelihood of bias.
Chief, you know, I've said it in this studio earlier yesterday, that look, anyone who is a lawyer, not like my good friend Koku Bako, who is reading around, any real true lawyer, trained, properly gone through the tutorials and pupillage, will not dare get up in any court and accuse a judge of impropriety or ask a judge to step down unless he himself has a certain standard, he's come to a certain standard of evidence that he believes that, look, it's about time we raise it. I've said it.
They didn't do it. It was for political reasons.
I'm just saying that it is a very, very high standard indeed to say that a judge is biased or the judge cannot be fair. You know, everybody will want to know why. What has he done? What are the reasons? Is it because he's, you know, chasing the other person's wife or that or what? Or you say is a sister who is before him? I've done cases. I've raised objection to judges before. Some have been thrown out. Others, the judges have recused themselves for various reasons. You know, I can tell you some interesting experiences in the 40 years or more. So, by practice, some very interesting. Where a judge goes to what do you call it, a magistrate, visits the house of the other side, and then my client comes to tell me, we live across. I saw the judge enter the house of during Christmas time. Oh, no, it was a difficult one, very difficult for me. I had to raise it. The judge recused himself immediately, but he gave a very good reason why. he went there. And I believe the judge, you understand? But it was very, now, I will not speak for Mr. Justice Atuguba. He speaks for himself. But I really hope that having withdrawn the objection formally, we should not be going that way. Or now you've withdrawn the objection, you now do not even have any ground whatsoever to ask Mr. Justice Atuguba to recuse himself or to be pushed out. Initially you claim you had grounds. Now there are no grounds. So why? You should recuse yourself. You get me? By withdrawing your whole action. Now, Justice, I think that let's not lose the essence of what we're saying. What we say that this is you said it, that this is about one of the, how do you put it?
I said the biggest legal battle in our political history,
Well,
perhaps.
in your lifetime. If you see that in Riakutu and all that, or something else, you get me? But as the biggest, largest case, we must be circumspect. The practitioners appearing before the court, the judges themselves, I'm telling you that the judges are very much aware of the nature of the case that's before them. You see, this is a case about the stability of the nation. It's the case about the way forward. People are feeling aggrieved by the electoral process. You understand? How should they behave? And I'm sure that all 9 judges who are sitting there are highly, tuned to the circumstances. You understand? So when Mr. Justice Atuguba comes out the way he did, I see it as some kind of a leadership statement, an ex-cathedral statement. We say it off, from the seat as a leader. That look, let's be careful. Let's not do anything that will break the stability of this country. Let's not chop, as he said, the fabric of this nation. This is the last stop for this country. We've gone to election. People are dissatisfied. Who have lost, they're dissatisfied. They've come before us. If we don't hold, we are the gatekeepers. We should be careful. What is wrong with that? He's a leader. He must set that tone. If he hadn't done it, some of us would have held him accountable. But
what was the basis for that statement? Was a political statement.
Don't go. Yes, of course.
Yes,
of
very
course.
serious political statement.
Why do you think that it's against you or your group?
No, not the fact that it's against anybody.
Yeah, so
no,
it's a-
no, but
Kweku,
I
no,
am saying
if
there
let me
must
just
have
land.
been a
Kweku,
basis for that
Kweku,
statement.
let me land.
If you make a statement of that nature,
Kweku, please.
when there's, I don't see what
Kweku,
precipitated.
can I finish?
Thank you.
Okay,
Allow
I'm sorry,
Nana
Frank.
to
Okay, I'm
continue.
sorry.
Yeah, but you have a lot of books to refer to, so don't worry.
I'm sorry.
I think that we as lawyers, we as lawyers in the whole country, we go to this courtroom in this big case, and we all have our fears and whatever. I'm sure that for the MDC, they also went there. They saw the judges in their minds. They said, "Hey, will these judges, do us justice or not?" These are normal fears and whatnot. They also do. That's not NPP alone that fears. You say, well, maybe the background of this judge or that man, whether in party-wise or whatnot. But these are all speculation. They should all remain in the mind.
And after there were actually threats that the NDC might also, be raising objection to a number of the judges. And Abuchi said rightly that in the end, we may not have anybody to sit on the matter then.
But that is why we must be circumspect as to what we say to those judges. Look, we should allow.
I think he's been so judgmental. And he's spoken for quite a while. And I think we should just let others.
He's spoken for 6 minutes. He's spoken for 6 minutes. I'm dealing with you. I'm timing all of you. I'm dealing with you. He's spoken for 6 minutes. Let him finish. Let him finish in the next minute.
Prof, I don't think I'm speaking too much. Maybe what I'm saying may not sound comfortable to you.
No,
but the reality is that. Okay, let me say this. I think that we should allow justice and fairness to prevail in this matter. That's the only way we can have peace and stability in this country. We should cool down our, emotions, our fears. All these all these press conferences the night before a case is heard, we should stop them. We should stop it. It's not proper. It doesn't help the judicial process.
Thank you.
I believe, and I think the NDC team believes in the judges. We know that we have the evidence, hard evidence, not Kokubaku's type of evidence. We will present facts. We will present, and our case will be heard, and the truth will come out.
Thank you.
That we
Thank you.
want hands down.
And I put this question to Professor Michael Quay. Have you not had situations in court where you clearly feel and have evidence to show that the judge does not look kindly on you, and yet because of the weight of the evidence you have, you move on? You move on and you don't raise any objection.
Let me come from the back, because I'm really tempted to make a few comments about some of the things my colleague, Mr. Tudazi, has pronounced upon. The basic issue that we're looking out for with regard to whether an application was proper and so on should not be lost. Because you see, if you look at the very excellent example Mr. Kwekubako gave about a man talking about a judge boozing, that one he's able to say it freely. When he has to come and make an affidavit now to make a formal application, he backtracked till today. Then in the meantime, you will find the same people making wild public pronouncements. And this is why you don't start this kind of application except in the way that I said. You do it respectfully, privately, to start with. When it is imperative, when it is absolutely necessary, then you can take other steps in the matter. This matter must be made very, very clear to the public, so that it doesn't look as if the lawyers for the petitioners were doing some runaway tactics and all manner of comments that you hear. Now, as to an evidence to show the judge does not look kindly on you, you know, there are times, that one is a matter of discretion, and also as to the depth of the matter. And that is why I refer to the first opportunity rule, and in fact the constitutional provision regarding that. When that happens, you have to take the step that you believe right. And that is why you want to start from the lower level, and if necessary, then to the higher level. The lower level is going to discuss this matter in chambers, in before both counsel. You know, if you know or believe that there's a real likelihood of bias, prejudice in a case by way of a judge, I will say there's no reason why you say, oh, my case is good. Therefore, no matter what, I will pursue my case without raising the objection. It may cost you. And I believe, therefore, that if you really know that what you are saying is right, then you must nevertheless go ahead and say it. But you must not do so frivolously. You must not do so without first exhausting that opportunity to do so in chambers. You must be mindful of the first opportunity rule. That is, if you don't say it at the right time, you may lose the opportunity to say it at a subsequent
So when
occasion.
you say it, you pursue it to the end?
No, it doesn't mean so. That because you take a first step, you will necessarily pursue it to the end.
You want to win your case. And if you think that because of that one individual you will lose, pursue it to the end because you want to win.
Yeah. If you haven't put...
Unless you don't have grounds. Unless you don't have grounds.
That doesn't mean you don't have any grounds. And very soon we shall talk about the grounds. And that doesn't mean abandonment. And you see, when such... Oh, no, I mean, I must, with all respect, when such statements are made, abandoned, run away, now they want to cause delay. They said they wanted everything to be open. They want even television to cover it. Now they want us to go and do the case Okukwem. Then you are creating, by propaganda, such falsehood that pollutes the hemisphere. I must say this with all seriousness. Especially when it comes also from lawyers. Because they should know what the first opportunity rule is. they should know that the process, no wonder Lions Kwasi did not agree with the NDC legal bench when that matter was raised, because he knows the law and he also knows the due processes in the court. He knows about the first opportunity rule, and he knows about the fact that by practice you discuss these things quietly before you go to go out. So you see, there are times when, as professionals, we must take away the propaganda and then do the thing professionally. And if you know that what a person is doing is the right way of doing it, why don't you go in public and start condemning him, knowing very well that it is only because you want to give the impression that, oh, you ran away, like you were saying, and so on. I think we as lawyers must do these things professionally, and we must advocate the professional position in public.
I've got some of your text messages here before I get a response from Anes Tabochi about the question I put to him. Now, Razak in Pandai writes, the NDC should also object to judges associated with the NPP so they will feel it. Okay, the NDC has indicated that they can object to as many as about 5. Jones Halfasini says, please tell the NPP and Nanado to stop fighting over nothing because this is a lost cause. JM and NDC for life. Cosmos KEEA writes, indeed, Nanado has proved to the entire world that he is desperate. He wants to become president at all costs, irrespective of the effect of his actions on the nation. Ghana needs peace. Mahama all the way. Okay, let's stick to the issues. I think that's what we'll do. If you want your text message read. Gideon Abuchi writes, the new position of the NPP not to challenge the composition of the panel of judges will in no way stop NDC's Chachuchi Kata from challenging relatives of NPP members on the panel. And Ata Imoro in Wellency writes something, I don't see the need to challenge the composition of judges sitting on the case. The evidence was presented to the court by the NPP, as presented to the court by the NPP, such that even if Seyedun Ketia is made the presiding judge, he would have no option than to determine the case in favor of the NPP. Don Fellow writes, NPP will be making their case worse if they continue on this journey of unsavory comments coming from party gurus. Ghanaians want a fair hearing and judgment. Ima Nyamite writes, the objection of the legal team of the Nanado is a legal strategy to put Justice William Atuguba on the spot and to let him know that all Ghanaians are closely watching. We must allow the case to proceed. Let us remain calm. And very finally, Simon in Waliwali writes something. Is it a crime to raise an objection on any of the judges sitting on a case or to go to court to challenge election results? No, it is not. Mr. Abuchi.
Well, as I indicated earlier, Samson, raising objections in court is a normal part of the legal process. It happens virtually on a daily basis. Well, not daily basis, but it happens very often. And many of these do not make the news. The reason this is making the news is because this is in a very contested case.
It's about the stability of the country.
The very stability of the country, and the Supreme Court is the final court of appeal, so to speak. And in this particular matter, it's even actually the original court, the court with original jurisdiction. So you lose there, subject to any review, you're done.
There's no review according to CI 74.
Right, I'm saying
which is also
generally in terms of his jurisdiction, if you lose in the Supreme Court generally, subject to any review, you are done. In this particular case, one particular decision and you are done. And so the stakes are even higher. That makes it even more complicated as we speak. However, we need to, and I think I'm just appealing to the various interested parties in this regard, we need to remember that Supreme Court judges, though they can be subject to the various objections of bias, among others, it is normally a very rare option that is not exercised that often. And I'm saying this because if you...
I suppose you've not forgotten about my question, that if what has happened already, even now, they're saying that they are not interested in challenging anymore.
The psychological
has there
blow.
not be any psychological
No, absolutely, I got that. I just want to answer it with some background. You know, it's important. You know, I'm just saying this because if you look at countries like the US and co, which is the normal reference point usually, virtually every judge is known for his ideological leanings. And therefore, before you bring a matter you would have calculated the ideological disposition of that particular matter, and you can almost tell.
You taught me that in jurisprudence.
Well, I can't remember this, but
American
you can
jurisprudence.
almost tell what the judge will say, and almost invariably goes in that direction. Indeed, recently, many Americans are surprised that Justice Roberts, for instance, voted for Obamacare, because they know that Obamacare is not conservative in character, and that man would hardly vote anything other than conservative. That is how the system goes. The Ghanaian Supreme Court may very soon probably be known for that, if not already known for that. So the issue of raising objections against judges, because you can almost tell by a certain leaning or a certain relationship what judgment he will give, in the case of the Supreme Court, is sparingly exercised because of the gravity of issues that go to that level. If you want to speak to that, you have to be careful and you have to know what you're
Is
studying.
it also because this is not a sole jurist, you have a panel?
You mean
That's why it is rarely, used in raising
well,
objections.
usually, exactly, because it's a panel, exactly. That's usually. But the votes invariably still make up what the panel is, and that's why it's critical. But that brings me then to your question as to whether this may therefore have a psychological knock-on effect on this particular judge. Invariably, as a person, one may say yes, because once the objection has been raised, it has become an issue of national importance. We sit here discussing him. He therefore might have been exposed in a way he might not be comfortable with. Would he affect him as a judge? If Justice Atuguba is a good judge, which I know he is, it would not. Judges, unlike the jury, are not usually affected or swayed by the public. Their judgment is based on the evidence that is presented before them. Their judgment is based on the law. Good judges, therefore, try to detach themselves from the emotional and other surrounding circumstances of cases. And so while this case is not an ordinary case, and therefore the psychological effect or the psychological issues attending this case might impact on him, given the fact that he has been, in a way, unduly exposed.
Would it be cowardly if he voluntarily decided to recuse himself at this point?
He would not be cowardly, but it creates an impression and a perception he would not want to countenance. The impression or perception this creates, remember, the legal fraternity may understand this. The lay fraternity do not. And the lay fraternity are in their numbers as a country. As far as they're concerned, there was an objection raised against a certain judge. The judge, in fear of his own exposure, decided just to create a blank. Don't even say it, I'm gone. It might follow him for years to come. We're talking just about Justice Henry Taban. Mr. Kokubako was talking about Justice Bobe. Some of these things create perceptions that follow people, even if that is not substantively the case. And I'm just saying that Justice Atuguba may not want to countenance that psychological impression or that perceptual impression that may follow him, voluntarily recusing himself. He certainly can. He can decide to walk away. But that brings us to the question as to the withdrawal of the petition, the withdrawal of the...
sorry, but he can decide.
The objection, yes.
He can decide. Would that be your counsel to him, to walk away?
No, totally not. Totally not, particularly because the Supreme Court, you see, there's a limited number of justices in there. And once you start having some of the justices successfully walking away in the light of objections, we may have some depletion that could actually affect the potential, that could actually affect the minimum requirement. At the moment, we certainly are not. We still have enough. But I'm saying we may just have that because remember that the political stakes involved in this case are of such a nature that I really do foresee the possibility of the other side going the same way. And indeed, there has been hints in that regard. I worry about a stampeding effect of the Supreme Court. And you may actually have scandalous and indeed embarrassing evidence that are being led, sometimes in some of these cases, an attempt to undo each other. In the process, you may have the court being bastardized. I worry because as we speak, the court is the last point of saving the stability of this country, which has just come out of a very closely fought election. And so I would hope that having withdrawn the election, having withdrawn the objection, the judge should continue sitting. And I was just going to speak to the question of the withdrawal of the objection, unless you have some other.
Go ahead, do that.
Yeah, but again, I think the issue of the withdrawal, a person who makes an application orally, formally, can withdraw at any time. But withdrawal.
Twin Block is proudly brought to you by Indomie.
Creates for the one making the objection and subsequently withdrawing is what might have changed. because you have created a scenario that has been discussed, and then suddenly there has been a withdrawal, assuming that the relationship involved is what is being discussed. The relationship hasn't changed. Assuming that there are some serious evidence, issues of evidence that has been gotten in respect of that judge, which fundamentally prejudices him as a judge sitting in respect of this matter, has that fundamental scenario changed? I think if the status quo remains, then it means there are even more questions why the status quo, in the light of the status quo, you would want to still proceed while you feel very uncomfortable with that judge, and what the effect might be if that judge writes a judgment that you find fundamentally problematic in the light of facts that have not been disclosed. So clearly there are serious perceptual issues that might have been created. And I think that is what may affect the issue of the withdrawal. And I think either Prof or Nana raised the issue of the fact that there could have been some sober reflection much earlier before the objection was raised. As was indicated, in court, the party could have, and I think that's where, when we were not sure, the adjournment could have been taken. That, the party wants to seek the court's adjournment in the light of a developing issue, and they would wish that the court grants the adjournment, they will come back properly before the court. I think that could have been done. But again, as I said, the exercise of the oral objection itself is allowed. It's allowed.
But you know that the Supreme Court, the Court of Appeal, they don't take these very lightly. You just
Absolutely.
go and make a comment without any without specifying that you want to take an adjournment and go look at something and come back formally.
Well, not taking an adjournment in respect of something you ought to have done, but you're taking an adjournment in respect of something that affects the bench, and you may want to come formally. Right. Again, you can keep things open. The court, if not sure, the court may invite you into chambers for us to talk, as was exercised. And I think that was a fantastic thing that was done. The hearing in chambers. It was fantastic because sometimes you don't want to scandalize the court in open court.
All right.
And I think lawyers and judges alike totally understand this.
This is Newsfile. It is brought to you in association with MTN Everywhere You Go and Bank of Africa. And I'll take you, Kweku Bako. Still more comments coming in. I'll read some of them. But I am thinking that if it did happen, as we are getting indications, hints, that the NDC legal team might also raise objection to some judges, will that not be petty and unnecessarily, bastardizing, a word you are fond of, the system? And I am looking at things that go to the core of justice, that go to the fountain of justice, bringing the institution down.
See, I would assess each objection that is raised on its merit and find out if it has any substance. That's the approach, because first of all, the law allows an objection to be made. And if the law allows that, then one should not seek to close that door. So each objection that comes must be looked at critically on its merit. So if now we are in the realm of speculation, I don't know which judge they were going to raise an objection against.
They have said they can get as many as 5 of them.
Oh, I've heard. No, but if we are talking about judges that had previous political background, there are many, and they cut across the divide. I've heard they mention, it's not fair. Am I entitled to mention a name? Yeah, it's not fair. So I wouldn't do that because I've heard names.
On the papers this morning, they have been splashed. Their photographs are there.
Oh, okay.
Yeah,
I haven't seen any.
I haven't
seen it, but I know judges. Look, I know judges who. There's one judge whose name has been mentioned, was a regional chairman of the NPP. He's a member of the Supreme Court.
That's the new standard.
There is a judge. There's a Court of Appeal judge who was a former regional minister. In fact, there's another one who is retired. I mean, they cut across, but that should, if you raise that issue, it's within context. How would that impact on the litigation? What is the interest you are seeking? Which level of bias are you deducting from that previous political association? But I'm saying that I don't want to speculate unduly. If they raise an objection to a particular judge, then we'll be entitled to come and analyze that particular objection on its merit. No, but this point about the psychological blow, I agree. As an individual, as a human being, it could be there, but perhaps with his experience, he may be able to overcome it. In the Justice Opon case, he recused himself, but you read the ruling he gave, you can see how hurt he was, and in fact, at a certain stage, even how frightened that he had become. So that shows that as human beings, regardless of your training, you could easily get, worried and think psychological blow. But there's something that the point that you didn't want me to make strongly. That statement Justice Aturuba made, what was it in reference to?
This is the statement he made. He said that, quote, this country is solid, but is breaking down because principles are being chopped down to pedestrian level. The cost must be strong and truly independent. The health of our country depends on us.
What occasioned that? No, that is not fantastic. A fantastic statement occasioned by what? Principles are being chopped down. Which principles? And by whom? And how? This is the president of the panel, and it means a lot. He's sitting on the joinder case. The case is just the case.
Yes.
This same panel might not necessarily sit on the substantive case. I hope we know that. This panel might not be the same panel. Yes. Might not, I said. Okay. Might not be the same panel to sit on the substantive issue, which is the election petition. He's sitting on the joinder application that the NDC has brought. Before they went into the chambers, where he then would have been made aware that you are the one we are talking about. He made this statement. You are saying that he was talking of the stability of the nation. The stability of the nation is being threatened by people chopping down certain principles. Which principles and by whom?
And the lawyers who are there and engaging in arguments, he's drawing the attention.
I think it's a prejudicial statement.
Importance of
listen
this
to
case.
me. It is a very prejudicial statement to be made by a president of a panel at the Supreme Court level. That's my view. It's prejudicial. It doesn't help anybody. What occasioned it? What had been said in court at that point in time that occasioned this loaded, fantastic statement? What occasioned it? So when you put yourself in that situation, you've created a certain problem for yourself. And I am saying that, yes, it might have been possible that the NPP raising that objection was to create this psychological environment for him to recuse himself. It's possible. I'm just speculating. It's possible that even what Titus Global also did was to raise public alarm, put him in a tight corner. But in court, nothing had happened to have occasioned this loaded, fantastic statement. And I mean,
assuming that your interpretation is what it is, would you feel a little offended if somebody suggests to you, Kokubako, that you do not have the competence to do your job professionally?
A judge
and independently?
Is over and above Kokubako. I'm just an ordinary person. I mean, behave that we see in their own code of conduct for judges and magistrates. I'll read commentary under the section 5. A judge must refrain from speech, gestures, or other conduct that could reasonably be perceived as evidencing bias or prejudice, and must require the same standard of conduct of others subject to the judge's direction and control, including those who are directly involved in courtroom proceedings. A judge must perform judicial duties impartially and fairly. A judge who manifests any bias or prejudice in a proceeding impairs the fairness of the proceeding and brings the judiciary into disrepute. Facial expression and body language, in addition to oral communications, can give to parties or lawyers in the proceeding, juries, the media, and others an appearance of judicial bias. A judge must be alert to avoid behavior that may be perceived as biased or prejudicial. I'm part of the media. I am saying that this loaded, fantastic statement and the body language that accompanied it, I find it prejudicial. He ought not to have created conditions for me to make this reasonable deduction. That's the point I'm making. I may be wrong, but I'm an individual Ghanaian and I'm making this view open here. And I believe me, if I'm put in that situation, I will voluntarily exit. I'm not saying that he should do so. My last point, and I find that also very mischievous and is deliberate. The request for hearing the objection in camera had absolutely nothing to do with the NDC rejoinder application, and also had nothing to do with the substantive election petition. I believe even that the law itself requires that the issue be held in open court. I've heard, and I think I even heard Nana also make that point, that the MPP had asked for televised coverage and suddenly had gone to court and were pulling feet and asking for something to be done in camera. I believe we're over and above that. That extension is clear and elementary in terms of the law, in terms of the request that was made in open court. It was to discuss the objection in camera that had nothing to do with the joint application or the substantive election petition.
I've got some of your text messages. I'll come to you now. I've got some of this one. You don't identify yourself. You says, what is NPP doing to this country? We need to know how Titus Glover got to know beforehand the composition of the panel and his categorical statement of knowing that Justice Atuguba was going to be part of the panel. This one to you, don't identify yourself. Be bold to identify yourself. No one will come after you. Nana cannot be our president even if he sends the case to the International Court. You say Hague? Well, he doesn't go there. He should better rest and let Mahama rule the country in peace. The symbol of the NPP. Okay, you see, that's what I just told you. I'm not going to read some messages that you send in if they are not directly in tune with what we are discussing here. Yusuf, right, says from Tamale that the problem with the NDC is not about the so-called evidence of the elephant, but the implementation of the Chapter 2 of our Better Ghana agenda. The NPP should realize that all the judges are Ghanaians and are related to both parties in one way or the other, either in the tribal line, geographical, or extended family. So they should think twice with whatever objections they intend to raise. Solomon, Santa Maria. There is nothing wrong with raising an objection to a panel in court. That point has been made. But it becomes worrying when it is done in clandestine and malicious manner. All right? We are getting some education also about the fact that there's no question of clandestineness about that. I hope the petitioners will include Kumasi Ayeduasi polling station. Vote cast in this area was done without the biometric verification machine. Okay, take that evidence to the petitioners. They need it. By Moses in Yendi, he says, I want to know whether the Supreme Court can declare a presidential candidate a winner in Ghana. Watch this process. You will soon come to the end. Mohammed writes, okay, sorry, I can't take that text. Akoko Sapong in Kumasi writes, sorry, can't take that. All right, so make sure that you really do want me to read your message. Otherwise, I will not take it. MTN, mega promo. Let me tell you about it. You've always dreamed of owning a brand new Jaguar. Now is the time. Live your dream today with MTN Dream Big Extreme. Just text WIN to 2020 now, and you could drive home a brand new Jaguar XF 2012 every month, or win cash daily. That's juicy. And in the grand draw, you could walk home with a jackpot of 120,000 hot cash. There are also loads of MTN goodies like airtime, smartphones, souvenirs, and much more to be won. So go on, text WIN to 2020, and you could live your dream with MTN Big Dream Extreme today. Partnered by Felop Ghana, distributors of Jaguar. MTN, everywhere you go. Nana, it was you that I was coming to at the point. Now, I want us to look a bit at some of the substantive matters in your joinder. Your joinder has been described variously, including that it is only intended to delay the process, and that you are really an unnecessary party to this, and you are saying that you must at all costs be joined to this process. Is it that you don't have faith in the panel, the team that the president has assembled?
Well, no. Thanks very much. Really, just one minute on what my good friend Kweku said. I think that once the NPP side, that is the petitioners, applicants, have said that they are withdrawing their application. Objection. We should let things lie.
All right.
We should simply let things lie. I mean, Kweku has marshaled all the arguments that a review court of the Supreme Court constituted by him as one person, you know, we may rightly say. But I'm afraid he doesn't sit as a review court in this matter. The people who brought the case say, we've withdrawn it. Let's leave things like that, you know. Of course, like my good friend Adam Sabuchi was saying, there are real serious matters about the psychological blow done to the judge. But I still also believe that he won't be the first judge, and it won't be the first time he has been confronted with that. Lawyers basically are trained to close one part of their brain, you know, and deal with the facts and matters and keep their personal emotions in there. At the Supreme Court, I believe that he has a capacity to deal with that. In any case, the people have withdrawn. So what's the big deal? So really, Kwagu, I think it's a storm in a teacup.
Yeah, but since you are still referring to that, the talk about the judge's outburst.
Yeah, but talking about
what it
yes, what I'm
suggests.
saying is that the judge's outburst have indicated, I've said clearly that he's the president of the court. He was setting a tone and saying that, well, look, we must all bring our mind to the seriousness of the functions we're taking here. I don't know, for instance, that before sitting that day, the judges themselves, the judicial, not just the judiciary, had tried to tune themselves up. They had changed their carpet, they've changed some chairs, they've changed the air condition. They had critically,
There's very heavy security.
You said they've done what? Oh yeah, they must have yelled at people to hurry up to clean up, you know, because they were critically aware that the entire nation.
But you are used to that as a lawyer, right?
Oh, absolutely. I mean,
But you are not happy when it happens.
no, not that I know. What the judge did, you know, immediately he brought us all into attention in the courtroom. Everybody was alert. We were all listening, and I said, like, he was telling everybody, this is the greatest case of our lifetime.
Briefly about your joinder, substantive.
Yes. So when I'm saying that, I think there's nothing really big do about reading the rules of court or the rules of practice or the ethics of the judges. He is he knows it more than Kweku.
I agree.
And didn't go through. So there's nothing wrong.
It's education he was giving to our listening and viewing public, and there are text messages coming in that they are enjoying the education.
Oh,
That
yeah,
all
yeah, I
of you
think so.
are giving,
I think so. And the point I'm making is that education can be misconstrued if you don't put it in proper terms. That there's nothing we say that the court should not set the tone. You know, the court can tell. Look, I know how this matter is. I don't want to. So. And then go ahead. But quickly, after the question of joinder, again, this is a matter which is before the court. I don't want to be the person, part of the team, you put a case in court, you come and sit outside and you're arguing it. But basically, again, as public education, as I understand it, the NDC is saying something simple. Look, under Article 55 of the Constitution, you know, the right to form a party is constitutionally guaranteed. 2, the right to sponsor, you know, candidates for elections to any public office other than district assemblies and below, you know, they are guaranteed. It's in Article 55. Now, political parties, you know, and it goes on out there, talks about all presidential candidates shall be given the same platform. Here's a case where the people, the man or the persons stood on the NDC ticket. The common knowledge, the logo, everything was the agents and whatnot were all NDC. You get me? The organizing committee, let me put it, that is the IPAC, the inter-party, you know, coordinating team, NDC, NPP. They actually set the tone. No verification, no vote. They were fighting with as it were, the Electoral Commission. They said, oh, we are satisfied, we can do. No, we must have this, we must have that, we must have that. So the parties have had a great and immense influence on the election and whatnot. Even the counting.
The no verification, no vote is law, really. Is regulation 30.
I'm saying that getting it into law. I'm saying, yeah, but getting it into law was essentially the work of the parties themselves. Understand? The effort of the parties. It's a fantastic thing. You see? Now, what I'm saying is that the counting, whatnot, their agents are there in the strong room in Accra. You get me? They are there. They sign before it's handed over. Now, all of that is party-centered. So, now, if you put it in that broader framework, that our constitution or political philosophy for now the quest for democracy is multi-party centered. You get me? It's multi-party centered. Then the preparation towards the election itself and the post-election issues must be, worked out in the framework of the party itself. That is why some people are even saying, look, this matter is properly within the domain of the IPAC, how to improve the system, how to do investigation to find out what went wrong, that MPP is complaining, what are the grounds, and all that.
No, they are not really talking about just improving systems. They are talking about votes that were stolen, allegedly.
I'm saying some people are saying that, but MPP have elevated it. They have used a certain word, transmogrified things into this matter, into a court matter. You understand? Fine. They brought it here, so we need to do. So what is the role of the party? Can the party which sponsored the presidential candidate, the party that participated in the mobilizing, organization, funding, and all that, why should they be interested? Basically, a joinder, as I understand it at law, is that if a person, you first of all must look at the claim that is being made. If the claim is such that a person may be affected by it, the court on its own may order that the person should be joined, that other person should be joined, if it's not endorsed as a witness, as a party. In the case of Ekwan versus Payne, Prof knows it. MPP was sitting in somewhere. The court ordered that MPP should be brought, they should be joined to the action. Because the matter, affected the MPP in a way. So they cannot just sit down and sleep. So in this particular matter, we are critically and vitally interested. Now, we, in this case, the court hasn't invited us, but we are interveners, as the law says. Interveners are persons who are critically interested or vitally may be affected by the case as it goes. So we think that, looking at all the circumstances, we are going to urge upon the court that, look, NDC should join, and as the lawyers say, it will enable the matter to be, effectively and effectually concluded once and for all, so that we don't have multiplicity.
These basic facts from you, Nana. The petition was filed on the 28th of December 2012. By law, by CI 74, the respondents have within 10 days to file their answer. The first respondent, the second respondent, that is the Electoral Commission, has filed its answer. It filed it on the 7th of January 2013. Do we know if the first respondent,
when is the cut-off date?
President John Dramani Mahama,
do you know when the last day for President John Mahama to sign it?
This is 28th.
So it will be when?
It was filed on the 28th.
I'm saying that so last day will be today. And according to the law, the registry is open, even on Saturdays and Sundays. So let's go and do your homework.
Okay.
The lawyers, they are very competent lawyers, backing
the So let me ask this briefly also.
I'm sure they will file.
Do you find that perhaps there is a certain process by which the NPP legal team must have outsmarted you? You have not been able to get your joinder as of this time. The NPP, the president would have to file his answer between today, by today.
Yes.
You have not had the opportunity. If you had been joined earlier, would the dynamics not have changed a bit?
Oh, no. Really, I don't see. So far, I'm sorry, but the truth is that they've been losing the psychological battle throughout so far. Maybe a few more.
Since you will not respond directly to that question.
In spite of all their press conferences,
since you will not respond directly to that question, let me come to Professor Michael Kwe.
You've been losing everything.
Let me come to Professor Michael Kwe.
It must have been clear to you that a lot of the propaganda, in terms of they say they want it public, they want it TV, now they want it gym. Now it's quite clear that all those things were propaganda. Because we were going...
Now this is my question. On the question of the joinder. The NPP, in the letter that we know about, the petitioners, in the letter that was sent to the registrar, is saying that they are no longer challenging the composition because they want the trial to be speedy. They want it to go on speedily. Why object, or why are you seeking not to disallow the NDC from joining? wouldn't it have been smoother if you had just allowed them and then the process would have run smoothly?
No. The NDC is essentially the respondents. Their legal team, as he's talking about, is quintessentially the same.
No, but they are different.
They-
There's the
wait,
president's
wait,
legal
wait.
team
This-
led by Chachuchi Kata.
This group, this
Yes.
the law by which we're talking about talks about, why couldn't they even have talked about institutions or organizations, a person or body? A person is the essence of this particular arrangement.
That's for
You
the
must be a
petitioner.
Ghanaian.
That's for the
Yes.
petitioner.
And pari passu, in the same way, Ghanaians who are also interested are sued accordingly. Nobody has brought the NDC there. The NDC can bring all that it wants to do by way of the respondent. The respondent, the first respondent, the president, now president of the republic. So essentially, they could let the case proceed with dispatch, and then all the legal ammunition in the armory, bring them to bear on the
The
matter.
question is
and let
that you
it go.
don't also lose anything if you had allowed them, and by now we may have had a clear way when the trial is going to start.
But if we consider it not an appropriate application, surely we must say so. But you see, let me just go from
whoever opposes a joinder as a general rule in practice, you tell me. Whoever, as a general rule.
a gender maybe. No, you can't.
I'm saying as a general rule.
As a general rule,
A
it may
joinder.
be frivolous, it may be vexatious,
general rule,
it may cause unnecessary delay, it may be an abuse of the process of the court.
Okay,
These are the
I
legal
think you should
principles.
focus.
Doing these things are done. And you know it.
Pastor Kwe, focus on where you were going, because
All right, very well.
you
Because
might spend your time on his.
Thank you very much, so that he will least distract. Now, you see, there was this statement, Nana, by a letter or a message. Nana wants to be president at all costs. It has been part
It was
of this,
one of their texts.
yes, one of the texts, and part of this maligning propaganda, which is most unfortunate. If you look at the history of this man, at the time that he was fighting for the rights of individuals, was he wanting to be president at all costs? In terms of the Kumipreku matters, in terms of people who were abused by military extremities, it wasn't a matter of wanting to be president at all costs. It's the matter of a man who believes in freedom, justice, who believes the right thing must be done, and particularly by due process of law. And that no wonder a number of cases were taken to court under his auspices, which have really gone to enhance the liberty of the Ghanaian and also to promote constitutionalism and also democratization in this particular country. We all know it so well that there's no point in beating that beautiful horse any further. But the fact is, could he also not have encouraged people really taking to the streets? People who had met at Obra, people who had other ways of handling this problem that they regarded as they having been cheated of a victory.
You mean extrajudicial means?
Extrajudicial means of all types, which have happened in so many other countries. This is a person, and I can assure you, he told all those who insisted on being belligerent repeatedly, let us seek redress in the court, because these have been well provided for in our constitution. It's not a matter of seeking to be president at all costs. It's a matter of letting due process be recognized in this country as the way of going about our affairs. My brother, elections constitute about 75% at least of political instability, of conflict in the whole of Africa. Elections. And not only elections that have gone wrong, people imposing themselves upon the people, even without elections, also cause problems. So the election that we conduct once every 4 years is a very important function. Slaves don't vote. If you're a slave, you can't vote. Somebody manages your life for you. Colonized people don't vote. colonized people also, they are ruled by their colonizers. It is only sovereign people who vote. Ghanaians have their various jobs. Some are teachers, some are lawyers, some are bricklayers, masons, electricians, and so building the nation in many ways. Once every 4 years, we meet to choose who we want to rule us. Whether by MPs, whether by president or vice president, we as a people choose. I think it's time we realized the very sanctity of the vote. It contains our sovereign power. It contains our authority. It is the only thing by which we can say, now I am going to do my teaching in my classroom. I am going to do my bricklaying. I want this person to rule this country for the next 4 years. So when we have an election where ballot papers are being snatched, where we have an election where it is suspected that people who are underage are voting, where we have election where aliens are voting and they are burst into the country, where we have an election where electoral officers' integrity are seriously questioned, and when we have an election where the rules of the game are allegedly being flagrantly disobeyed, then something really has to be done. And that is why you will find that in this country, 251,000 ballot papers were supposed to be spoiled. The last election, about 220,000 were supposed to be spoiled. My brother, the unexamined life is not worth living. When are we? Should we simply say, it has just happened, it's okay? Some people want to contest these things in court to establish the best practices once and for all. They cannot be maligned. And that is why this kind of propaganda and so on must stop. Looking at this particular matter, there is this serious statement that by CI 75, by our law, we need to go through a verification process before we vote. The law says clearly that we have over here.
Regulation 32.
Yes, that the voter shall. We had a number of views. That is not mandatory. If there's another way of identifying the person, then it must be done.
You are being asked the question that these issues or problems you are raising are now issues of administrative problems and do not amount to stealing the elections.
That is the fallacy of that argument. And it is a matter of the preponderance of the evidence. And someone says, I am holding in my hand a preponderance of such evidence.
Of such evidence
yes,
that all the people who went to vote without verification voted against Nana Addo Dankwa Akufo-Addo.
No, no. The point is that if there is so much of this, that it goes to show that something significantly irregular was done in the process, then of course that process should be set aside. Because you see, at any given time, some people are in charge of the process. Some people are responsible for the obeying of the rules. And if this happens such that a large chunk of voters are allowed to vote without verification, then what was the verification for?
All right.
We had the election postponed from Friday to Saturday simply because of verification. Some people could not vote on Friday, and because of the fact that verification machines had broken down, these machines were provided on the Saturday.
All right.
Then it means, therefore, that it is an integral part of the legal process.
I'll take the final submission on this subject from Mr. Bochi, and then we'll move on to look at the question of the caretaker president. No, but I thought that I had done a certain round. Okay, we'll do very briefly because we need time to move on to the caretaker ministerial, ministerial matters and the president's cabinets. Now, this one says, will the petitioners' lawyers be ready to accept the verdict of the Supreme Court on this matter, taking into account the fact that Justice Atuguba is still a member of the panel? That's the question. Mufta in Bogatanga writes, Samson, if the court declares some declares one can vote without verification, those who were denied voting because of verification, can they then take EC to court for disenfranchising them? Why not? From Issa, he says, this court case is just a waste of everybody's time. Leave it and move on to other important issues. Someone says, just to remind your panel and viewers that the US presidential election of 2000 had a similarly contested results. Thank you very much. Yusuf Mobila in Tamale writes, the Supreme Court must be fair in their work to prevent parties resorting to, that's what you meant, use of guns, cutlasses to fight for their rights next time. Omar in Tamale writes, the withdrawal of the objection by the NPP is dangerous. The NDC team should be very careful. Thank you for your advice to the team. Now, Mr. Bochi, my question to you is similar to what I asked Nana Atodazi earlier. Seeing that the NDC didn't get the opportunity to join, and now if they had been able to join earlier, before today, which is the date that time elapses for the president to also send his answer. If they had had the opportunity, would things have changed?
No, but just before that, I can assure you that the president's defense or answer will be filed.
That's all right. I'm saying that you do not have the opportunity to be a party before he files. Does that change anything?
No, it doesn't. It doesn't. If you are responding, you're asking of the president's response.
That's so.
If you're responding not necessarily with reference to what some other person might have said, who the parties are. You are responding to a specific allegation, to specific points of laws that may have been raised by the petition, in this case the petitioners. And so the fact that the NDC has not been joined at this stage would not of itself affect the president's response if the president responds today.
All right.
If you're asking for that legal point, no, it doesn't substantively affect it at all. And in respect of the issues of joinder generally as raised, a court would consider whether or not a party's being joined to a matter would help in the determination and ultimate determination of all the issues involved and whether it would be in the interest of justice to all concerned. So the court looks at the global issue, and I think my understanding of what's going on so far is the NDC claiming that as a political party and having sponsored the president, they stand to materially lose or gain on the basis of whichever decision is rendered by the court. I am quite reluctant to make a statement on the balance. Which of these two claims makes a lot of sense, because this is a matter which is before the court. And I think I would just generally also say that we should also again create boundaries for ourselves in some of the discussions, because a lot of the issues are before the court.
That is so.
And judges and justices listen to some of these programs too. It is not professionally acceptable.
You're answering a question I was going to put to you about how the media should handle it.
Right. No, I think the media should be quite circumspect. The general principles are always okay when you're discussing them. If you can stay at the general level, as much as possible, the issues of evidence, and I think Prof and Nana have done that today, refer to some specifics as regards some of the issues of evidence. These are issues that are going to be presented before the court.
That is so.
And I think that, I know sometimes we are led by emotions and we just stray because they know these. If we can do well to stay within the general, and therefore avoid the particular, because the particular is going to go before the court. And
the very learned counsel, Samuel Kujeto, has said that he has called on both parties to stop the commentary in the media. But you can't avoid that in this matter.
No, you can't. But ideally, parties who are members of the legal team, ideally should not come to the studio. Ideally, because what you do, and I know often you call them on radio, it's part of the problem. They have
appointed spokespersons.
Well, that's fine. Exactly. Oh, yes, spokesperson. Excellent. Okay, so that's fine.
Okay,
excellent. Okay, I didn't know that.
All right. Now, Mr. Bochi, briefly, very finally and briefly for you, do you see this case getting to the end of this case anytime soon?
If the parties are all true to themselves, and if the parties are all focused on the ultimate goal, this case should be ended very soon.
A friend of mine suggests that we might see this case end in the next 10 years.
Well, 10 years is too long, but it might go beyond. It might go beyond this year if
Nana says it could be longer.
well, it might go beyond this year if, and that's what I'm saying, if the parties decide to play the legal ball, which is what we're seeing at this stage. And I think that the withdrawal of the objection by the NPP is a strategic and a tactical decision which makes a lot of sense, because that objection was just going to spawn counter objections because they stand to lose with delay. The biggest loser in any delay in this matter is the NPP, because the NPP doesn't want this matter to go on the longer and to make it much difficult if possibly things have to be reversed in the opinion.
Okay.
So they stand to lose the greatest, and therefore their withdrawal makes to me the most tactical sense.
And sorry, but I almost forgot also that there is the pending writ by Bernard Mona of the PNC,
Right.
which is challenging portions of CI 74, which is the amended Supreme Court, rules guiding this particular process, and they are challenging two portions. The first part is that the rule amends the Supreme Court rules to say for presidential election petitions, there is no review of the decision. And they say that is unconstitutional. And to the extent that it is unconstitutional, in contravention with the Constitution, must be declared null and void. Also that the rule says that the hearing can be on holidays, including Saturdays and Sundays, and they say that also, is a contradiction to the Public Holidays Act. I want to know from you: is it the case that you feel that the Supreme Court may have to determine this matter before it goes to determine the petition by the NPP before it?
By the logical tenor of events, yes. Because what it means is that if the Supreme Court determines the substantive case, and subsequently, and of course, and there's no review, and subsequently this is upheld, then you would have had an anomalous situation created in the events that parties would have said we should have gone on review, given the fact that we're challenging the fact of the absence of a review involved in this case.
So this is one case that will also
that could
delay
have
the
created
process.
delays. And that's what I'm saying, that, first of all, you need a strong Supreme Court to, at a certain point, say, we're going to consider all objections, we're going to consider all motions in this way. We'll finish it, and then we'll go to the substance. We have a timeline we're going to follow, and we're going to try hard to follow that timeline.
All right.
That is a determination the Supreme Court can make, but it's still very difficult in practice because motions and counter motions and objections are always allowed in court proceedings, and this is one strategy lawyers can use to ensure that time can be defeated sometimes in some cases if they stand to benefit from that. And I think in the circumstances.
Now, before I come to you, Mr. Bako, briefly, Professor Kwe, I want you to look at this. I've heard some members of the NPP suggest that Bernard Moden's case, it's he just being a decoy, as it were, being used by the NDC to bring this and to further put, spokes in the wheel, but and to frustrate the NPP's process. But I am thinking that members of the NPP who are thinking this way are not thinking about the flip side. That if the court determines this matter and says, for example, that there can be a review, it's inures to the benefit of both parties. So that if it happened that the NPP lost the matter, it will have the opportunity of review.
Well, the important thing is that the Supreme Court has brought specific rules with regard to what the Constitution has provided in the peculiar circumstance of the president. This matter, some people say, is only NPP which is in a hurry. But I tell you, it is not in the interest of the president of a country to have an albatross hanging around his neck. It can affect foreign relations and foreign contacts and contracts. Some bodies, persons, or authorities may want to deal with Ghana in a certain way because they think that there is a certain still transitory nature of the authority. I'm saying these things can happen in international relations. It is in the interest of every person, body, or authority in Ghana that this matter should be dealt with very, very expeditiously. And that is why you realize that the rules provided specifically with regard to this particular process, that the hearing must be done day to day, holiday or no holiday, Saturday or Sunday, and so on and so forth, so as to finish with this matter. And in fact, even gives the number of days after the close of case, where within 21 days, there must be what? A judgment. The court must go work morning, noon, and night and bring us a judgment. Well, with regard to the matter of anyone seeking a review, you see, the Supreme Court is capable of dealing with this at the time when there's an application for review by any of the parties. That is, if it interprets that the law should allow a review, then of course, it will go ahead and hear the review. If it says that it holds the position that there will be no review, then of course that review will not be heard.
Okay, so what you mean is that that rate can actually be determined after the substantive
exactly.
of the petition
so
by
the
NPP.
It does not necessarily make us delay this matter.
I get
so this case can, as the position stands, and mind you, as at now, that is the legal position. If you want to challenge the legality of it, the Supreme Court, that is a process until that objection is sustained.
All right.
Until that case is won, what is the legal position? This is the legal position as of today.
That is so. Thank you very much.
A forum must exist before you can apply to it. You understand? So
that's
really,
interesting.
This is really the issue at stake. But just quickly, Buhari versus Obasanjo in Nigeria is an election petition. 300 witnesses were called. It took almost 18 months to 2 years to try. You see, what we are dealing with, we're going to deal with evidence.
I'm getting the hints from you that you're suggesting that this indeed could go beyond 10 years?
Well, no, I'm not talking about time. It depends upon the number of witnesses they've got to call. If they are taking a pot shot at 4,000 polling stations, as they are saying, I get scared. You get me? I'm just telling you that in Nigeria, it took, for 300 witnesses, it took 18 months to 2 years. Now, the point about it is that, you see, for each polling station that you contest, you must produce evidence.
All right.
All the things that you are saying, these are all allegations.
Well, they will do so. They will do so.
You've got to produce 4,000 witnesses.
They will do so. They will do so. And I come finally to you, Abdul Malik. Yes.
Exactly.
And briefly.
They indicated they will be calling about 23 or so witnesses.
The number of witnesses to be called are indicated.
Yeah, it's indicated there.
I'm not going to give them any free advice. I'm only saying that.
Of course, when they are done, they will have their turn. And they have the opportunity to call the witnesses they want after cross-examining if the opportunity exists. Now, sorry, but we need to move on. Abdul Malik, very finally from you and briefly.
You see, the Constitution 64.1, it speaks of a petition by a citizen.
That is so.
If you go into the CI 74, you talk about petitioners or petitioner or petitioners. I was looking through the definitions area and I see something about respondent. I'm reading CI 74.
All right.
Respondent includes the person whose election is challenged by a petition.
That is so.
And the electoral commission, where the petitioner complains of the conduct of the electoral commission. So the electoral commission as a corporate entity or a body is being captured within the definition of a respondent. In this case, the person who is being challenged was the president-elect, who is now the president. Both the Constitution and the CI 74, my layman understanding or reading, you don't see a corporate entity, with the exception of the EC,
Electoral Commission,
mentioned. Of course, I am aware that generally you can make a joinder. I'm aware it's a general principle that is allowed. But I can't find any room in the election petition, both within the context of the Constitution and the CI 74, for a corporate entity to join. So that's what perhaps is good for this matter to appear for determination, because it will move us forward. We will then be able to cross that hurdle.
These are matters before the court.
Yes, exactly. So I'm not judging. I'm saying that it is useful.
Come to court and enjoy.
That's so.
I am conceding that it is a grey area, and the fact that it's been brought forward will help us. That's the concession I'm making.
Okay.
I'm not actually making a
That's
determination.
important because you don't know what happens in the future.
Yes, that's it. That's why I'm saying that's a good point. No, but Bernard Monas.
Yes.
The first impression I get is that Mr. Raymond Atuguba will recuse himself.
Yeah, he's
from.
Well, of course, he's got a firm. He's got a firm,
No,
so
but
I'm sure
I'm
that
talking
they are.
personally. He would.
Yeah.
He was on air defending, explaining issues. It's obvious that he will
Prior
not,
to his appointment.
That's right. And now that he's been appointed, obviously he cannot continue with that exercise.
Maybe I'll do it. I'll take that.
For all you know, yes. But you see, the points being raised, again, I might sound judgmental. The Chief Justice, I'm informed, I'm educated to the extent that he's the head of administration of the judiciary, isn't it?
So,
And I'm wondering whether the head of an administration cannot fix the schedule for the administration of that outfit. Then when it comes to the review place, this is just thinking aloud. This one, Article 133.
Sorry but I think you should just mop up that point in relation to what I say in there. That she can't
because
mop up.
as
There's
you
this,
see,
there's this
determining-
point that the holidays,
Okay.
weekdays, and those things that I think through a directive,
Right.
which I'm told is within the Courts Act. You are the lawyer. You
It's-
tell me.
It's an internal
Yes, internal
yes.
administrative action.
Yes.
And I'm wondering, as head of an administration,
Right.
under Article 125, is it? Is it 125? Yes, 1254.
Right.
The Chief Justice shall, subject to this Constitution, be the head of the judiciary and shall be responsible
Right.
for the administration and supervision of the judiciary. I'm wondering whether that doesn't give her the basis for certain days for the judiciary to work. And that within that context, I suppose this directive about working on holidays and the rest.
It's
I
not a
can-
directive,
and even
it's
these
a
rules
rule.
of court.
Yeah, it's a
Right.
rule.
Yes.
Right.
So that's the point I'm making.
Right.
It's a rule. This is
It's within her powers.
74.
So the point I'm making is that it has both legal and constitutional basis.
Correct, yes.
And then when you come to the review thing, the problem, 1331, the Supreme Court may review any decision made or given by it on such grounds, and this is the emphasis, and subject to such conditions as may be prescribed by rules of court. This thing about 71B Rule 55 does not apply to a decision of court in respect of petition presented to challenge the election of president.
Yeah.
Is it done by the rules of court?
That is so.
So I think that also has legal and constitutional basis. But of course, the Supreme Court will decide all this.
And to add to what he just said, you realize that it is from that same principle that matters of bail can be granted on Saturdays and Sundays. As I know, my learned colleague knows very
So
well.
these issues are before the court. Let's
know,
leave the court,
No, no,
the
but-
Supreme
but-
Court.
and-
to determine.
and
It's a
also, let me
substantive matter.
also say
So I
this.
really don't
No,
see
no.
why this
All
embellishment.
right. At this point, at this point,
I think I must add
at this
that
point,
this-
gentlemen,
These are
at this
preemptive
point,
there are matters.
Let's leave it.
at this point,
Otherwise, we don't want
distinguished
to be sitting
gentlemen,
here at all.
distinguished gentlemen, let me take one or two of my text messages and then we'll go for a break and we'll return to wrap up. Now, Samuel Aquayong writes, how far can fraud travel and how strong can it be in the face of truth and justice? Philosophical. Gunu Yendi writes, oh Allah, save us. Why has the NPP made a U-turn? They should stop deceiving Ghanaians and concede defeat. Schiffman in Atonso writes, is it not sad that people who want to take due process to seek redress are termed as desperate? Please, we must stop the hypocrisy and ensure that peace prevails through justice. Queen in Dom writes, please tell Atodazi to take it easy because the battle is still the Lord's. And that is one of the slogans of the NPP. This one says, I believe the NPP is doing Ghana a favor by testing our constitution, by going to court to seek justice. But looking at their posture around the issue, that's where you end it. Now Salma Janga in the northern region writes, NPP is being smarter. They have succeeded in exposing Atuguba to the world. Exposing him in how? In what sense, you mean? Ebo Taifa writes, Kweku Bako, thank you very much. Kweku Bako must be giving an honorary call to the bar. Wow, he is at par with some senior lawyers. Kweku, you have spoken more like a lawyer than Nana no, that cannot be the case. It says his presentation can best pass as a propagandist. Yeboah in Awoshi, writing that one. Okay, Nanado is never desperate for power, as NDC claims justice must reign supreme over partisan interest. Nana and Co. shall accept and respect the court ruling. NDC should declare their position. Of course, they are in court defending. Ishmael writes, it's legal. Is it legal to contest elections in court? It's legal to contest elections in court. So people should give Nana Addo a break for doing what is lawful. The NPP will indeed deepen democracy in Ghana by losing their ill-thought case against the Electoral Commission and His Excellency the President. D-Love, Achimoda writes, please ask Nana Atodazi if the NDC will file a motion to reject some of the judges. Okay, this question is coming, is about the second message. Edu, we also write, I think the NPP is in court to help to eradicate cheating by incumbent governments, the weaker parties, and the weaker parties in our beloved country. Joshua, NPP is praying. Sorry, can't take that one. Ask the lawyers, how many votes has the presiding judge, or what are the powers of the president? What are the powers of the presiding judge? If 5 vote against 4, can he or she change it? If the Supreme Court can declare someone, all right. Thank you very much for those messages that you brought in. But Mr. Bochi, just this briefly, in 30 seconds, he's asking that what is the presiding judge votes? Has he got more votes than anybody? And if you have a vote of 5 against 4, what does it mean? Can it be changed?
I don't understand. The presiding judge has 1 vote, just like no casting, nothing, just a single vote.
Okay. All right.
So if it's 5 against 4, if the presiding judge is in the minority, he or she writes the minority judgment, leads. Okay. And then the other side, they choose whoever leads the majority. But there's nothing like casting votes.
Thank you very much. This is Newsfile, your most authoritative news analysis show. My guests have been Professor Michael Okwe, former second Deputy Speaker of Parliament. He's a lawyer and has spent extensive time writing on politics and teaching politics as well. Ernest Kofi Abochi is a senior law lecturer at the Gimpa Law School. Nana Atodazi, former Chief of Staff. He is a member of the NDC legal team. He's got about 40 years experience at the bar. And Kweku Bako Jr., he's your pocket lawyer giving you the precedents. He is the managing editor of the New Crusading Guide newspaper. The last issue we'll look at very briefly before we exit the studio. I have been asking the President, John Mahama's appointment so far. There seems to be a certain, agreements or suggestion that he's moving towards a professional presidency and an all-inclusive technocratic cabinet. You would find, so it's suggested. But there's also the question that is being asked whether he got wrong legal counsel when he gave directives for ex-ministers to hold on as caretaker ministers. On this note, I start with Nana Atodazi. Yeah. Let's first look at the composition briefly. The composition of the team that's out so far. There are suggestions that you have PNC members in there. You have members who are not in the people who are not NDC, members. You have the former Vice Chancellor of the University of Cape Coast appointed. You also have designated. You also have Nana Oyelitha, not exactly known to be an NDC member, and that's a suggestion. What's your view?
Well, thank you again. I think having been in the Chief of Staff for some time, and be in government for nearly 19 years, I kind of can read some of the signs of the times. Quite clearly, the challenge of winning the election is to run a government, transparent government that can deliver and really raise and lift the lives of our people. That's the basic thing. Otherwise, as the former or the late president said, then you don't have any business to be in office. Now, to do that job, you know that the executive powers of state are completely vested in the president, head of state, head of government, commander-in-chief. He can't do everything. So the Constitution itself also gives him the power to, appoint people who do, like, if you like, it's like men. These are ministers and other appointees. Now, for the beginning, you come out to the election and immediately you are confronted with the business of governance. Who and who do you call on to work with? The first things you do is to look at what the legal regime which we have to operate. The same constitution also says that ministers should go to parliament for vetting before they become ministers. It's a very complex situation. So if they have to go, what happens during the period that between assuming office, 7th January,
midnight of 6th of January,
okay?
everybody ceases to have any
and then Parliament be coming to force and also vetting these people. It takes a bit of time. So the Constitution, unfortunately, is a little quiet on that. We face this challenge in the year, I believe, 2001 or so, or 1996.
It was 96, 97. J.H. Mensah versus Attorney General.
J.H. Mensah went to court. He said, what do you call it? The carryover ministers should not be allowed. The court, of course, the Supreme Court looked at all the circumstances and said, no. It will be, inappropriate to let the president be there without people to work and all that. And so they said they could carry on the work, but for a short period. You understand? Now, my brother and I, Professor Prof. Okwei, and I were the Kwame Ahoy, all of us, we were part of the transitional team that worked very hard over some years, and we came out with a transitional bill, now Transitional Act. Now, within that act, I think you have a copy here.
Yes, I have a copy here.
We try to capture some of the weaknesses of the system in the past. Those things.
But you didn't make provision for this particular.
We did.
What ministers should do?
We did.
You did?
Yes. Actually, if you take a look at Transitional Provision 14.5, you see, it was a transitional provision. The assumption of office of the person elected as president, a person holding any of the offices specified in the schedule shall drop. And we list the number of persons who come and go with the president. Then it says that those who cease to hold office, their work shall be performed by persons so appointed by the president. But we are talking about the people who appoint, maybe people who may have to go to parliament for vetting and whatnot.
Is it a may or shall?
No. I'll come to it. It's a shall. Shall be performed by a person so appointed by them. Now, in 5, that is 14.5, you see that there's a small provision. So before the assumption of office of the incoming minister, a person so appointed by the president shall be in charge of the relevant ministry, but shall not take a decision involving a policy issue except in the Ministry of Justice.
The ministers who are being asked to be caretakers have not been appointed by the president.
That's exactly so to that extent.
And if they are appointed by the president, they are subject to parliamentary approval.
No. That was the issue that was resolved by J.H. Mensah and the Attorney General. I'm saying that in that way you define them as the person. I mean, it depends upon how you describe them. You can say they are caretaker, whatever, but in the act they say that the president has a right to appoint a person, you understand, to hold the fort until the new minister goes through parliamentary process and whatnot. So it is a very interesting, I thought we didn't, but it is right there.
Okay, thank you. Professor Kwe, what's your perspective on this?
Well, before then, let me just answer a couple of things that came out from the reaction of the public. How far can a court go? How far can fraud travel? All these
I
things.
don't normally allow this, but
Oh,
do it briefly.
really?
Yes, because we have moved.
Well, it's so pertinent. I don't think we should leave it in a limbo.
Okay, briefly.
I mean, to what the public are thinking. And that is the reason why these things should be discussed. Look, the law doesn't say you cannot discuss a case because it's sub judice. You should not say the outcome, if it should go left or should go right, or this is the proper way. In the United States, when a matter goes to the Supreme Court, and in fact, I will expect people from the law faculties and so on, send the judges' opinions. It's an opinion. It does not tell it should go here or there. Address it to the registrar. Because many people may not know, for example, that in the Ukraine, a case went to the Supreme Court, and then they reversed the decision. And if our public don't know these things, they will even wonder what is all this about. And it's very, very, very important for people to therefore know that this is the essence of a particular person's case, and that in certain cases, such decisions also were made, and that a case can really be obtained. And that, for example, if the Constitution provides for a situation whereby the president may have to step aside, and who will take over, it might be discussed so that people will not be afraid. And also that the Constitution itself foresees that possibility. And it provides, for example, that whatever was done by that president in the interim will not be nullified because he has been removed from office. So these things are, to my mind, very, very, very important. Once you don't go beyond the boundary of saying that this is what must happen and that is what must happen.
Okay.
Knowledge abounds. And if you pick it for internet, you should be able to talk about it for us all to know.
All right.
With regard to the Transition Act, it's unfortunate that there was a certain spirit, and luckily my good friend, Honorable
Nana Atodazi.
Nana Atodazi is very much aware of this, in terms of seeking the security and the continuity of certain key state officials, including IGP, so and so forth, which unfortunately were later on abandoned so far as the security of tenure of this was concerned. We felt that some of our problems have got to do with the tendency to over-politicize everything, not by one party, but by us as a people. So that the spirit, for example, of the temporary appointment or a temporary application was that this was to be done by the chief directors in the ministries for a short period. Because you see, when you talk about directives and nomination, then you get into some difficulty. Because by our constitution, a president doesn't appoint by directives. He appoints by a nomination to parliament who does a process and so on and so forth, which we all know. This is what creates some of the difficulty in people's minds. But the fact is that J.H. Mensah as Attorney General, the result is very, very clear. That is, we cannot have a lacuna in the Republic. We cannot have a situation whereby nobody's in charge. And that is why the statement was made that for a reasonable period. But sometimes too, what is reasonable? And because of the difficulties of our politics, we want to really tighten people's hands so that you don't just give them reasonable period, you give them fixed period. So I believe that definitely there must be a tightening of the rules. But sometimes when you talk about the Transition Act, we forget that it continues. It also contains things like handing over notes. It also is a way of handling the presidential estate. That is making sure that whether it's cars or buildings and things are all well looked after and accounted for. And that, in fact, it's not just a matter of government alone acting, that there is an advisory team which is headed by the Speaker of Parliament. These go to ensure a certain amount of checks and balances during that short period of the transition. But one thing is certain, no matter what happens, by the authority of J.H. Mensah as Attorney General, we cannot have a situation whereby the ministries are empty. Only will have been gladder, especially all those who were involved in that process, if the chief directors who are anticipated to be the caretakers should be made to act in that state accordingly.
Thank you very much. I recognize the lack of time we have. That's why you would find that in the discussion, a part of the question is not being addressed, but we'll move on because we don't really have time. Now, I'll come to you now to take your view on that issue, Mr. Abuchi.
No, I mean, I have been looking at the Transition Act, and my opinion, you know, and I know that the distinguished persons who worked on the Transition Act are here, but my opinion is that the Transition Act creates a problem, or it introduces a difficulty. Clearly, they were trying to address a standing issue, a standing problem, especially that culminated. We know how the 2008 transition went, and I think we're trying to address some of these issues. But clearly, my opinion, and my very humble opinion on this point is this: there is never a gap in administration. Administration is a continuous process, and we all know and understand that. The minister is a representative of the president in the ministry, nothing more than that. The entire bureaucracy is there. He just comes and is at the head. So here's the policy who is distinguished or distinguishable from the technocrats and the mainstream administration.
The chief director and the rest
Exactly,
of
headed by the chief director. The mainstream administration continues. Whenever we have this situation, this lull between the point of a new appointment and between elections and a new appointment, the chief directors traditionally have played that role, and in my opinion, fairly well. And the ministers come and complete whatever policy issues are outstanding, and then administration continues. What we have had by the introduction of, Section 5 of subsection 5 of Section 14.
Yes.
What we have in this particular provision is to make the minister another administrator and take away from him what he is used to, which is mainstream policy. Ministers are policy oriented, and the chief directors are technocrats, administrative oriented. If you make the minister mainstream policy and take his mainstream administrator and take away from him his policy role to which he's used, what you're going to have is a possible duplication of function here between the minister and the chief director. When the minister is not used to doing that, he's used to the regular policy-oriented work. Administrative work can be very ministerial in the sense of being mechanical and routine. And ministers are particularly not used to that. So once you take their policy functions from them and say that they should, in the meantime, only be doing administrative work while they await eventual appointment of ministers, I think you create duplication and the danger of a conflict. As I said, the rationale is clear and we understand it, but I think the way it's been couched, respectfully, it's a bit problematic.
All right, Abdul Malik.
Okay, just a little point. I think that you need to draw the distinction between the civil service operation and that of a minister. There, in various laws, legislation, some jobs can only be executed by a minister, signing the final warrant and all that. So if there's no minister, then those specific things, for instance, if there's no minister for finance, you mean that for the next 1 month, nobody's going to pay.
Correct.
No money will be.
No, but that's exactly the problem.
Just a moment. Now, to cure that, you see, that short period, a person is designated a minister into that position to sign. And you see, the executive authority vests in the president. And according to the law, he designates, he dispenses, So it is for him to write to somebody, in fact, informs Parliament and write to that person that you sign for me. You sign as Minister for Foreign Affairs.
Parliament was not informed, and they were worried about that.
But that's the key point.
But you agree with me that the essence of J.H. Mensah and Attorney General is to avoid a situation of having acting ministers.
Yes.
That what happened in 1996 when you had the incoming NDC administration, old ministers acting as ministers, and the court says you can't even act.
But the J.H. Mensah did not say that the civil servants should do the work of the ministers.
That's the point. So
I think that's why this is a transitional
I know we have statutory problems
thing.
because some instances you have a minister who is required to sign. So I see the difficulty, but legally, I'm not sure it's been addressed there.
Okay,
well, at least we have a transitional act in place.
Well, Abdul Malik.
Those who've been appointed, the ministers, you call them caretaker ministers. That's your description.
That's the description that was given to them by the letter communicating.
Really?
You know, the information.
No, if that is what
Yeah.
is contained in the presidential letter or directive, then I have a problem with it. You know, because they can't be ministers. They can't be caretaker ministers or acting ministers. They can't be. And there was no reference to Parliament as well. Because once you're making reference, no, please come in.
No, you see, chief directors would have signed for and on behalf of the minister.
That's right.
And even in the absence of a minister, and because law doesn't allow gaps, in the absence of a minister, where the chief director signs for and on behalf of the minister, he's actually acting on behalf of the president.
I agree.
And that is called
fantastic.
But this one is a problem.
Kindly let me read the B part of that letter, the press release that came to the media. The B part says, for the orderly conduct of government business in the period before ministers of state are appointed to head government ministries, and in the spirit of the Transition Act, His Excellency the President has also designated the various substantive ministers, including regional ministers, whose tenure of office expired at midnight on the 6th of January 2013, in caretaker positions of the various ministries and regions they previously occupied.
Well, it may sound commonsensical, but whether it is constitutional and legal is another matter. No, I think it just shows that perhaps there was an oversight.
The caveat was that they won't take any policy decision during the period.
Yes, but I mean, I don't see where the problem is at all in this. The president is a person who is vested with the power.
Executive authority.
It's a presidential government.
No, the executive powers. Now, the Constitution...
Regulated by the Constitution.
Oh, yeah, absolutely. And the Constitution says that the executive authority of Ghana shall extend, subject to provision of this, the function conferred on the president by clause 1 of this may be exercised by him, either directly or through officers subordinate to him, which gives him the power to delegate. So he has, by this letter, I don't care how it is couched, but this letter clearly says it. He's delegating.
Yes, but they are not ministers. Or acting ministers.
Look, the minister, I'm saying that the minister, the powers of those ministers derive from
yes,
the
but
president.
once you describe them as ministers.
Acknowledge one reality, that the word minister is a term of art. It is not just a normal word.
Yes.
It's a term of art under the Constitution.
That's right.
And therefore, when you designate someone as a minister, that person must comply with the constitutional requirement per judgment.
That's right.
Now, if we go beyond that, the difficulty I have with this current scenario is that the president can directly exercise ministerial authority in ministries. The president can do that.
Yeah.
But once he designates some people, call them caretakers, call them acting, because we know that in law, the acting person has all the powers of the substantive. That is the law. That is the position of the law. So if you appoint me to act in your stead, I have all your powers. And by the same position, I have your limitations.
Yeah.
If the president designates someone to act as a minister, that person may, in the meantime, be, for instance, let's say there's a statutory requirement, and there are many instances, permits for all kinds of things. Minister must sign. If the acting minister signs as acting minister, my position, and I think the position of the Supreme Court in the case of J.H. Mensah, is that that person may, in the circumstances, as per the powers of an acting, is acting really as a minister, and he hasn't gone through the process.
Yeah.
A chief director would have been different.
Yeah.
A chief director would have been signing that as a technocrat acting on behalf of the president because of the absence of a minister, which happens all the time. Yeah. And when a minister comes, he can actually just continue the process.
Let's not be too
technical.
Just
remember that there were a lot of issues in the transition bill recommendations.
Oh yeah.
If I went, when my friend talks about our working on this, we're working under the auspices of the IEA.
Yes.
So as to bring the basic recommendations.
Did you find that this was a problem?
No, it's because of the changes that were made, and that was why.
Because if you found that this was a problem, and gentlemen, you were part of the process, you should have cured it.
Yes,
No,
yes, I'm sure
where he
that
collapsed.
no, listen, please. This was one of the sticky points, right from '96, and it will continue to be a sticky point. I just want to say that, look, we cannot just live by the four corners of the Constitution alone in interpreting a constitution or a statute. You must look at it all. But at the same time, we must also develop conventions and customs and whatnot. So there are areas you may not find in black and white.
I agree.
Here.
That's why I'm
so
introducing
the
that.
transition document itself.
With the greatest respect, I see your point, but that is exactly why I'm bringing out even the practical difficulties.
Yeah.
And one of the practical difficulties is the duplication of the administrative function between the minister and the chief director.
But I thought that
which creates
one,
a problem.
that
And that is why the
line
recommendation-
that the work of the administrative echelon is totally different from that. And that without a minister, whether called acting caretaker, we may not get
We have just about a minute to go. In one word, tell me, what word would you use to describe the appointment so far?
Oh, I think that basically it's been sensible. And
Sensible.
fair,
Thank you very
and
much.
fair because it's been regionally balanced. And the
Abdul Malik,
people
how
are
can you
fit
do that?
to do it.
Well, it's too early to judge. Of course, the first four shows an interesting shift. I know it is created some undercurrents in the party.
You mean the presidential?
Yeah, the staff,
Okay.
those are the cast. There's some nice, I think it's not a bad shift, but it's worrying some other entrenched interest groups.
I see.
But it's too early to make any serious
Okay.
judgment.
Prof?
We are observing.
You're observing?
Yes.
Okay.
Well, I think it's
Yeah.
well. I think it's a blend of the status quo and new faces, and therefore we are all watching.
All right. Thank you very much. You have been listening and watching Newsfile here on your Joy News channel on Multi TV and also on Joy 99.7 FM and on affiliates across the country and online as well. I am Samson Ladi Ayenini. My guests have been Abdul Malik Kubaku Jr., Managing Editor of the New Crusading Guide newspaper. Ernest Kofi Abochi is a Senior Law Lecturer at GIMPA. Professor Michael Quay, former Second Deputy Speaker of Parliament. He's also a lawyer. And Nana Atodazi, he's a member of the NDC legal team. This show was produced under the executive leadership of Sedem Ofori. Thanks to you, Yaya, as well, and all the team. Have a good afternoon. The news is next.